San Diego employment attorney Ward Heinrichs is back on Big Blend Radio's Happy Hour show because he loves happy hours with us. I know. But he's giving us the lowdown on all the new California employment laws for 2019, and I think all sides of the aisle, in other words, employers and employees, you need to hear about this. His article about it is up on blendradioandtv.com. So just type in Employment Law 2019 or type in Ward, and you'll get all his articles and interviews as well. He is a regular Big Blend Radio guest and expert contributor, not only just to Big Blend Radio and TV magazine, but also to our Parks and Travel magazine, because he covers what's happening in the world of tourism and hospitality. But you can also keep up with his blog and podcast. Go to bestemploymentattorneysandiego.com. He's on Twitter and Facebook. Just type in Ward Heinrichs, and you'll find him. So, Ward, welcome back to the show. How are you?
Thank you. I'm doing well. How are you doing, Lisa?
Doing good. Nancy and I are gearing up to realize that in 4 months we're going to be on the road full time for 3 to 5 to 8 to whatever years, documenting parks and stories from the communities. And a bunch of our, partners and friends have sent us up on you're going to get these specific type of stories. You're going to, every town you go to, you need to look for public art. One person, you need to look at what they're doing for their kids. Everybody's got all these different things. And I heard from our little, Priscilla, our little sock monkey travel mascot, she whispered in my ear before you came on the show and said that you joined that group of friends saying, we're sending Nancy and Lisa on a mission. Is that true?
That is true. Ooh. Absolutely. And what I think might be a great mission for you is to gather as many historic law and order stories as possible. And when I mean law and order stories, like you go to Tombstone, see what Wyatt Earp was up to, maybe look back at an old newspaper, whatever it is, and see what kind of things you can find out about historic law and order stories.
Ooh.
I like that.
Okay, so we're going to do this.
I love that.
Nancy, you game?
Law
and Order?
I am way into this because I love Law and Order.
Well, we got a lot. We've got the Diligent gang that came here.
The Dillingers, yes.
Right here in Tucson. And we have a hotel, so that, that kind of sneaks into employment law. If there were shootings in a store or in a hotel or a fire, can that happen? Does that cross over into the employment law side?
Well, I guess there could potentially, at least nowadays, back in the early 1900s or late 1800s, I'm not positive. They didn't even have child labor laws yet. But if it was anything like today, if someone gets hurt at work, they certainly could sue someone for that. Again, if it's not work comp's a whole different thing. And so injuries, work-related injuries, or work comp. But you could sue if someone comes in and does something bad. And maybe the employer's on the hook depending on what precautions or whether they're on notice or a bunch of other things. So, that could have an effect. Now, of course, first and foremost, that's a job for the police and a prosecutor. But after that, maybe employment law would be part of the mix.
Okay,
because there's kind of a thing with employers are supposed to provide a safe working space for the employees.
Yes, that's true.
That's now. But back in the day, they didn't care.
Well, they may not have had a law like that, in the late 1800s.
Okay,
I don't
but
know.
What about if someone did a heist? What if the employees robbed the casino, right? We're going to Nevada. I'm just saying, and we got casinos all over, but Nevada's our territory. If someone did a heist and it was an inside job for the employees, does that even come close? No? Do they have a manual back then saying you will not do a heist?
Yeah, you will not steal stuff. It's really, of course you could terminate someone for that. At any time in the last 5 centuries, you could just terminate someone for that. But again, if you're stealing from a casino, like Ocean's 8 or Ocean's 11, then that's really an FBI matter.
Well, what? There's George Clooney's involved, so I don't care.
But
I'm going in. If it's
You're not the only woman that feels that way either.
I know.
There's other ways to steal. You can embezzle and play with the books.
Yeah.
As opposed to let's go open the safe.
You never know. This is going to be fun, Ward. So now we're going to report back to you, and you get to tell us the difference. And this is exciting because I know you like history. I know you like military history, too. You served, in our country,
absolutely.
so thank you for that. And so this is going to be really interesting, and I can't wait when we go through California because I know some dudes that Black Bart, Nancy, up in Central California.
Yeah.
You got some stagecoach heists. You've got some privateers even. Oh, I'm excited. I'm very excited about this. So everyone, you can follow our stories on loveyourparkstour.com, and we'll be checking in with Ward as we travel the country, and he'll tell us what was really legal or not, and it'll be fun.
I'm going to go look up some hanging judges.
I know. There's a lot of hanging trees out in the West. I'm just saying, not necessarily a good thing, but that's what it is. But, hey, Ward, so let's talk about employment laws for 2019. We'll fast forward to the future. This is an interesting year. This is always a big conversation of the year with you is like what's happening the next year. All the laws are changing. Some things have been gradually changing step by step, like minimum wage, so that's a thing. But the harassment thing is hot, man. It's like, I mean, I'm not saying that in a, happy way. I mean, it's like steps are being taken. But for everybody, it seems like from your article, whether you're an employer or an employee, there's different protections now in California for you.
Yeah, after the big Me Too movement of the last couple of years, California's really decided this year to step up the game and protect harassment victims, or at least even potential victims, more than they have in the past. So there have been, many laws that have been passed that deal with those types of issues. That's true.
It's complicated,
right? Let's talk.
It's not easy.
We'll
Often
get to the money
because
money's a part of it, and the minimum wage, that's been something. But let's talk about the harassment defamation protection because this is really interesting because there's been a lot of accusations. Can you prove it or not? I mean, I just even go to Anthony Bourdain's girlfriend and go, that's some weird stuff that went down there. I don't even get into it, but, it's weird. How much...
Yeah, there were some weird situations about that, no doubt.
I'm just sad about Anthony Bourdain, quite frankly. I'm like, God.
His show was great. I loved his show.
He was the best, right? He was the best in the world, and I wonder, Nancy, keeps tabs on that, too, about what happened to him. Did he, end his life over, his girlfriend that he thought was really amazing standing up against Weinstein, and then yet she turned around and did the same thing. Was it that? We don't know, but this stuff runs deep. When you think about the Me Too movement, and some people were innocent and some people weren't when they were standing up and speaking out. So it's kind of a interesting thing. So tell us about this harassment defamation protection.
Yeah. Well, I mean, the good thing about the Me Too movement is that people who have suffered harassment and discrimination and other types of related issues are getting some more protection. They've always had some. But the flip side of that is it's also easy to expound, maybe even lie about whether it happened or not. And so a common defense, and it's grown over the years, is, well, if they're going to say I committed harassment, then I'm going to countersue for defamation because it's not true. And so the legislature said, that's happening enough now, and we're seeing it used in a way that we don't think is always proper. Certainly, clearly, there are times when it is. I mean, we've seen it in the news. But we want to make sure that those defamation claims don't overshadow the harassment claims. And so we're going to get some more protections for those people who end up getting countersued for defamation, for lying about the harassment. And the legislature said a few things about it, but they said that you can only bring a defamation claim against a harassment accuser if there's credible evidence and it's without malice. Now, quite frankly, that's kind of always there anyway. But I think the idea is, well, it's now in a statute, and the courts will take that more seriously. You may even be able to knock a case out early on that if you can establish that kind of thing. So I think it just gives it more teeth than it's had in the past. And then, I don't know. I don't want to go too fast on this. I mean, does that make sense to you?
Yeah. It's really it's such a complex thing that I think that steps like this had to be made, it's complex. Each thing is different. So is any other state doing this kind of looking at what are we going to do to protect the person that may be innocent or both, and then the person who's speaking up and saying, hey, and then there's always that weirdo in between that's full of it, that ruins it for everybody. Because honestly, if someone's done something bad, they should get nailed on this kind of thing. Honestly, get nailed.
Absolutely.
Yeah, and for someone to go up and speak up on things, there's so many reasons why people have been quiet in the past. It's a very difficult process to go through if you have been abused or harassed, or and it goes in different. That in itself is complex. It's all complex. But then you have these, people in the middle that should just shut up and not mess it up, for the people standing up for the rights. And then you've got people that get defamed. I mean, this was federal, but are any other states looking at this as well that you've seen, or is it California?
This is not federal. It's actually California. It's an assembly bill that was started. That means it started in the assembly and then it goes to the California Senate, and it's been passed, and now the governor signed it. So, are there other states doing this? Honestly, I don't know, and I'm really sure because I haven't heard about the Fed part. I practice California law, and federal law often just doesn't apply because California law is more protective. There are times when it does, but so I focus more on California law. But I still, even though I don't focus on Fed as much, I've not heard of something like this where they're really trying to at least reinforce the rules of evidence and make it more likely that increase the protections for those who are accusing someone of sexual harassment. And I don't use, sometimes if I say accusing, someone might think, well, they're just blurting it out and they might not be thinking about it. It might not be true. No, that's not what I'm talking about. I'm really talking about the person who is really struggling to come to talk about this, and the legislature said that situation happens enough that we need some more protections against the aggressive potential harasser who is now countersuing for defamation. It's not always a countersuit either. I mean, it could be they get accused at work, and the person says, well, they may lose their job or they may get punished or it's just a hassle. And they go, hey, now that this is over and I see you're not filing a lawsuit, I'm filing a suit against you because you really made my life difficult. Maybe you ruined it. Maybe you got rid of my job, and now I'm coming after you. So it's not always a countersuit. But what the legislature is saying is, hey, we want to make sure that these countersuits are on a solid basis. That's really what they're talking about, suits or countersuits for defamation.
But how do you discern between okay, I said this, but it was obviously a joke when I said it, and then later in court it doesn't sound that funny. It really doesn't. So because in the workplace, there's men and women, and there's flirting, and there's women and women flirting, and men flirting. Now everybody's flirting with everybody, and it seems like a daily thing.
And now no one's talking to each other at all.
And it's so you never know, especially with cell phones, who's recording what and when. Yeah. And so it's almost like, what kind of workplace is there when everybody's afraid to speak, be jovial, if you want to call it that? I mean, it just sounds really odd to me. It's like maybe nobody should talk to each other.
Well, certainly you can talk about work things, and you're safe if you don't bring in any sexual innuendo. And when I say sexual, I don't mean, intercourse. I mean, any like you said, interaction that's playful between the sexes. Or like you said, it could be intersex as well. But, whatever the situation, if you're professional, then maybe you don't ever bring that up. And you just leave it alone. And you do that outside of work. So that would be the safest. But is that practical? Well, not really. Some of that's going to go on no matter what. So then, you got to draw some lines. You got to have an idea of what really is acceptable and what isn't. And it's really helpful, I think, if someone crosses that line. And everyone's line's going to be a little different. Yeah. And so you just have to respect the lines of others when they say, and hopefully they'll speak up and say, I'm very uncomfortable about that. And you may go, what are you thinking? Well, I'm just having a good time, and I don't mean anything bad. And that's really what that person's the person's mindset who said that stuff. But you got to be sensitive to the receiver too. And if they just don't like it, then you're just better off leaving it alone.
But isn't it true? Like if the person is higher up in the company than you, then it really becomes kind of like if you're two salespeople sitting in the break room and one says something the other one doesn't like. It's not the same as if it's your boss who says something you don't like.
No, right. No, absolutely. And California law recognizes that they have a standard of what we call strict liability for discrimination and harassment by a supervisor or a boss. If it's a coworker, it's not what we call strict liability, meaning that if you can prove that there was harassment, then you lose. If you can prove there's harassment to someone who's your coworker, then they have the ability. Then they have to show that there's notice. So I'm getting into some technical things, but the employer has to be on notice of coworker harassment. If they're not on notice of it, then you can't bring a claim. Or that's a defense. We had no notice. We didn't know. So the employer would be off the hook if they can prove that there was no notice of co-employee, people who are on the same level. If it's a superior, then notice is presumed.
So was part of all of this, doesn't that go into the one new law is about sexual harassment training so that people do have this awareness? What's going on?
Yeah, you know what? And that's in my article. I sort of buried that, and I should have probably put it up toward the top because that's going to affect more employers in California than any of these other new changes, especially in the harassment law. I mean, of course, the change in the minimum wage is going to basically affect everyone. But the sexual harassment training is going to affect a ton of employers because before, only employers with 50 or more employees had to train the supervisors. It was 2 hours every couple of years and 2 hours within 6 months of being either promoted to a position of authority or being hired on in a position of authority. So, but now it's 5 or more employees. So if you have 5 or more employees as an employer, you have to do that training now. And that's a huge difference. And there's so many more employers now that are going to be required to do this type of training. And they've expanded the training. You also have to give an hour of training to employees.
Wow.
Yeah.
Okay, so you employ 5 or more, and that doesn't matter if it's part-time or full-time, right? This is like, that's it. You're in.
Yes. Right. Yep.
So you could be a little shop, a retail shop, and have people part-time and maybe one manager person, one who's full-time, the typical thing, and you could just be, kind of, that's your tax write-off business. Sorry. Just know it happens. But that could be your thing. You have a shop and you have a manager, you have a full-time employee, and you have 3 others. And that's it. Now you're going to have to do this. And they could all be women, and you're all going to go and have a harassment training because if you don't, then you're in trouble.
Yeah, and I would say in today's work environment that even if you're all one sex, it's probably a good idea to do it.
Yeah.
Yeah,
Yeah.
because it happens on all sides. Okay, excuse me.
for
There are
sure.
women. I've been in.
Don't even.
I've been in a business situation where the women
Or
were really terrible. So
Mm.
really disgusting and terrible. And yeah, I mean, I would have liked to have not been in that room at that time. Thank you very much. You know, so it happens in restaurants. It happens. I think I honestly know that when you're in the hospitality industry, the entertainment industry, stuff's going to go down. It just happens. Or if you're in a sales industry, in sales,
Yeah.
when there's that group rah-rah environment, something's going to happen somewhere from anybody. I don't care what gender you are, it's going to happen. And there you go. Just saying.
Yeah.
And if cocktails are involved, that's when stuff happens too. There's, sales groups that go out and they go on a business trip together in a region. Publications do that. They go into a town. Here we go. We're going to go sell advertising. There's going to be 10 of us in one town and all take over a hotel. And what do you think? I mean, that's kind of like if there, things happen.
And can I just point out that a lot of publications have closed?
I know, but you know what I'm saying. There's some weird stuff that can happen in so many different circumstances, and you have to look at all sides of this. So yeah, you're right. So the training thing's now happening, but that's going to be. You said okay. So temporary employees, they still have to have like an hour, right, of training.
Well, for temporary employees, if you're a supervisor, the same rules would apply as for supervisors that are not temporary. But the thing about temporary employees is they usually don't work long enough to be gathered in under the old rule of 6 months. So what they've done now is they said all employees, whether you're a supervisor or not, who are temporary have to have at least 1 hour of training within 30 days or 100 hours of work.
Oh, wow. So Dirty Santa needs to have training.
Oh, Santa needs
30 or not.
Well, yeah, it depends if he works 30 or more days, and it depends if he works 100 hours.
So if he works 31 days, they need to do it. You're like, that's
and I doubt most Santas are going to work that long, probably, because you're going to start after Thanksgiving
like
and then.
Wow. Okay.
Yeah.
Okay.
So
when
unless
training,
they do 100 hours, but that's going to be hard, in that amount of time too.
When you say training, is there some state course they have to go to, and they get a certificate at the end that they can now, like once you've done it, you can go from job to job, and here's I've been trained, or
no, you'd have to redo it for each employer, so the clock would start over for each new employer. And it's not a certificate; it's a requirement of the employer. So if you get a new employee, now you have to train them within the specifications. The employer does the training.
Your office trains you?
You can do that. Yes, you can. Now it has to. There's some minimum requirements to develop the training, but a lot of it's you can get the minimum requirement training even online.
Yeah. It's going to be on HR. Is going to do it, right? And so like when you're looking at businesses with multiple employees that have an HR department.
I have visions of this old man boss with a cigar saying, "Come in here, new employee. I'm going to train you on sexual harassment."
Oh, nice, nice.
Well, I mean, you're supposed to meet some minimum requirements, but the employer is allowed to do the training.
Whoa.
Yeah. Okay. Well, that's why you have HR, and that's why you have all these manuals, and you do have things, and you have to do it.
Does he have to be, or he or she be qualified to train in some, he has to pass some kind of course in order to be the trainer? Not
that I know of. I don't think so. I can go in and do training, for instance. Now, people assume that, I got a law degree, I know what I'm talking about, but I don't have to pass a course. And so there is no course that you have to pass in order to be qualified for the training.
But
Okay, so everyone call Ward
wow.
because he's got the degree, and if you're going to do a law degree, geez,
So
hello,
the
that's
persons doing the
hard.
training have no qualifications to train.
Three of the worst things in life is getting, passing
Oh.
the bar, becoming a doctor, or a real estate agent. Those three things, or more, like all that, those three things, shenane. Um, but that's difficult. But if you can't, that's okay, Ward. So half of these bills are like kind of empty. I'm just saying. Am I allowed to
I don't
say
think
that?
it's empty because here's what I really think happens in most cases.
Okay.
Employers who are willing to spend a little money on this go out and get agencies or attorneys. I mean, there's various people who provide this. They're like outside HR or whatever. And so they'll spend a little money and have someone who has the training available to do it for them.
Okay.
Now, but there are also trainings that you can get, for instance, from the Department of Fair Employment and Housing, and they're the ones that do they're fair employment, and they're the ones that run the FEHA, the Fair Employment and Housing.
Right.
So you could actually go online and get the training course from them. Now, is it going to be as effective as someone who does it all the time? No, because they'll probably read it or just put it up on some screen for people to read and not have a very interactive process because they don't do it. Now, maybe if they're good presenters, they'll think about it and really work on it. But it's a side thing. It's a side gig for a general employee, so it's just not going to be nearly as good, in most cases. So you can do it. You can do it either way, and you're allowed to develop your own too. So, someone in-house can do it. But like you said, you should pick someone who is going to, one, kind of know what they're doing, HR or whatever. And two, someone who has a decent presentation skills is a really good thing. And then three, you can supplement any of your in-house programs with stuff that you can get online too and to make it more effective. And if the person's a good presenter, it probably won't be too bad.
Doesn't this always go, you always talk about the importance of, number one, knowing these laws, and that's what's so great about what you're doing and educating people because it's just hard to keep up, right? And I know HR people, I watch on Twitter and there's I know HR people that they're like, Ward stuff is up there, let's go check it out, because, there's this thing, keep up with it, and I think it's really difficult, and because things are changing super fast in our world, in our country, things are changing, and I think it's so important that you do take those steps. You always talk about take those steps because it's interesting. We had a cybersecurity agent on our show, and he's like, you need to keep a record of who you are. So the more you are who you are out in the world, on the internet, then people know you've got a footprint that shows who you are. And that's pretty much the same thing as when we talk with you. You always talk about take those steps because every time you take a step, if something negative happens, you have a backlog of I tried everything I could, man.
Right.
Here it is.
And I got to give the other side of that coin though for employers, because I counsel employers fairly often, and I'll say here's the way to reduce your risk the most. Take all these steps, and someone maybe they don't employ very many people. They go, I don't have time. And I say, well, I can do it. Well, you're really expensive. And I go, well, I'm not as expensive as you think. but I go, all right, you have to understand that you have risk, and there's other ways. Ways I can help you reduce that risk. So what I really try to do is talk to employers about picking the method that works for you given the expense and time commitment. And just know that there's a better way to do it probably, but if you're willing to take on that risk, then you're doing the best you can. And so that's really how I try to manage employers by saying you're trying to manage risk. That's your main thing here, and you can go 100% and, that's the best. But maybe, again, maybe you just don't have the time. And that does happen, so you just got to work with people.
Risk is a really good way. Now I want to play the game Risk.
Okay, but I want to ask, is there any kind of insurance for this kind of thing?
Oh,
Yeah, there is.
That's a
Sure. I
whole-
mean, if you get sued, sure, there's insurance for this kind of thing. Insurance has changed, though, over time. There used to be wage and hour insurance coverage, and I don't see it anymore. I'm sure it's out there somewhere, but it's just not as prevalent as it used to be. But for harassment and litigation and defense, yes, you certainly can get this type of coverage.
I want to go back to the training part, right? So we talk about sexual harassment training. And so this is also happening in regards to talent agencies. So I just want to know what kind of talent we're talking about. I just want to make sure that, I mean, are we talking about like a modeling agency? Are we talking about an acting agency? Or are we talking about the little shiny, the gentleman's club next to the family restaurant on the side of the road? What are we talking about here?
Well, this may be broad enough to cover all of them.
Oh, wow.
But there was a real sense of an industry that was both modeling and acting that did not take care of, especially the children, models, who got taken advantage of. And that's been a pretty hot topic for, the last year or so. So California said, hey, look, and maybe they wrote this very broadly, and I honestly, I'm not sure. I really can't venture an opinion on that right now, but it really might cover everything. But certainly it was directed at these modeling agencies and acting agencies that represent especially children, but can be adults too, and they, talked about more protection for adults as well. So now if you're an adult working with one of these talent agencies, the agency is responsible to give them sexual harassment reporting or sexual harassment educational materials on reporting, retaliation, and prevention.
That's good.
And then the children of between 14 and 17 years old actually have to have training that would do the same thing as the material they handed out, and that training also is for their parents as well.
And this is also going about eating disorders too. So there's not just the sexual side, but there's an eating disorder thing that's tied into that as well.
It is. It's all the image stuff. The harassment goes with the image. The eating disorders go with the image.
Wow. And but there's a whole crazy sex ring in Hollywood, and in all the big communities of celebrity, that people are talking about, and there's it's pretty gross if it's true. I can only read what I read, and you don't know until it gets proven, and when you read about it and you hear like what a lot of the child actors have seen, it's like they say that when you have made it as a child actor or an actor, there's some pretty disgusting stuff that is happening in not just Hollywood. I'm just like whatever communities, with these really, the Illuminati's coming out after you, man. Whatever, But there's this stuff happening where it's pretty bad that it actually starts to verge into the world of human trafficking and sex trafficking. And I mean, I don't know until it all comes out in the reality land and justice has taken course. But there's some bad stuff I've been reading that I just go, and that some of the suicides of celebrities that have happened are not really suicides, that it's like a fake suicide, and because the other side knows that they're ready to bust them. They've been keeping track, like Chris Cornell and people like that they were about to bust this big ring and working with the FBI on it, and all of a sudden these people started, dying through suicide, and that it's not. And I don't know if it's true or not. I'm just saying this is what's out there, and until it all comes down, we don't know. But what's going on in especially the world of child actors is horrific, and if it's tied to all of this sex trafficking and human trafficking, I'd love to see it shut down. It's disgusting, but we don't know because I don't know.
Yeah,
all I
and
know
that's
is what you can speculate, right?
Yeah, those are the salacious stories, and I'm sure some of them are grounded in truth. Maybe some of them aren't. But I think that's part of what the legislature was trying to address.
Wow, this is interesting. So now, gender representation on a board of directors. So now, check this out. Women are moving up.
I knew you were going to talk about that one. You weren't going to skip this one.
What if there isn't a qualified woman?
Yeah. What if you're okay? But anyway, no. But let's see. Let's explain what's going on this. So yeah, let's see first what this is about.
Yeah. By the end of the year, by the end of 2019, publicly traded companies that have an executive office in California have to have at least one female on the board of directors. And it's possible that they may need as many as 3 females, and I think that's later, though. I think that's by 2021, depending on the size of the company.
And that's the thing. You're going to look at a board of directors that you're going to have someone qualified on those numbers. I mean, when you're looking at how big a board is, right? And then you're saying up to 3, depending on how big the company is. So, no, but I mean, it's like, what if they're not qualified? I mean, Nancy and I are all pro women being everywhere, but what if they're not qualified? It's
I think it's a good question because because some women are not always given the same.
Oh, we're so going to get emails now, Nancy. Damn it!
I don't care. Bring it.
You didn't say that.
No, but what if women in companies sometimes don't get the same training and education as men, and so maybe they're not ready to take over or be on a board?
We're still getting emails.
So are they just going to stick you on because you're a woman?
Whew. Yeah, I'm glad you gave me that one. Oh boy. I suppose, and I'm going to say this in general terms, anything that's mandated, where you mandate that a person of any type of background, whatever, if you mandate it,
token.
Then I guess it's possible that might force someone into a position of some type of authority, like a board of directors, who wouldn't normally qualify. But then you got to ask, well, why wouldn't they qualify? Well, maybe it's partly because of, in this case, their gender. So honestly, I'm not too afraid of that, really, because I think there's enough women out in business that you can find people who will be qualified. And that doesn't mean that every man who's on a board now is qualified.
Exactly.
I never said that.
I did.
Well, I did. Nancy, I'm glad that you're concerned about it, and requiring passing laws like this, I guess, can have that downside effect. It's possible, but I don't fear that. Personally, that's not my personal gut feeling on it. I don't fear it.
No, I don't either. And come on, Nancy, you know better. There's a lot of good.
There's a lot of people thinking that.
Yeah.
And,
Nancy has to play devil's advocate. She's good at it.
She is. Holy smokes!
I like to look at things from.
But that's because a lot of people are going to go, well, how do you know? It's the same thing as when Hillary Clinton ran for president.
I hate the
idea
what's the
of being difference?
I hate the idea of being on a board just because you're male, or just because you're female, or you're transgender, or you're gay, or you're this, or you're that. I think that you should be on a board because you bring something to the table.
But this is a step towards that.
And so I would like to see boards of companies comprised of somebody, you have this kind of talent. You bring marketing expertise, or you bring accounting expertise, or you do something.
But this is a step. This is a step towards it.
Not because you're male or female.
Yeah, but it's a step towards it because women haven't been getting the salaries. They haven't been getting the promotions, the training.
I get it.
So you need to have this in between.
I think they should take an intelligence test.
Well, if we did that, then...
Well, that's an interesting angle on it. Rather than requiring people from different backgrounds to be on, maybe we should require people to take certain tests, and whoever passes it, whether you're male or female or whatever,
you get it.
Again, then you get problems with, is the test biased? But let's assume you can have an unbiased test.
Okay.
Well, I guess that would be the fairest. That does sound like the fairest way to do it. but I think the people who say, well, maybe that could potentially be fairer, but there's been so much unfairness over the centuries that we really need to try to make up for that. And if we get someone on who maybe isn't quite as good because of this, we got to live with that because we're really trying to correct past wrongs.
And work together. Can we just all work together? Why
can we all work together? Exactly.
Come on, people.
So, wow, Nancy, you got me off in that. I hope I don't start getting emails.
I know, man. She's like that, man. You know how she is. But that's the thing, because it's we look at what's going
about these
but
things.
Because at the end of the day it still gets political no matter how you look at it. And so as women we get these things too, and as women we're talking amongst ourselves about changes happening all the time, and it's not just about, midlife crisis or like, did that happen to your boobs? Did they go that way? It happens at that time. But that's I'm saying about women. We're talking about like where we're going. How do we progress? Do we always have to march and put little pink hats on? What do we have to do to do things and make a change? And so, it's a hard road, and women sometimes aren't helping women.
No, that's true.
And that's
right,
part of the problem.
Mm-hmm.
And sometimes it's like, okay, are we fighting this when we should just fight this up here? Like, where should these fights be going? Are we just, we're pissy over our lives over the last, whatever years of things of happening? Or, there's just this level of where do we fight? And I think it's a very interesting time. And this fight has been going for a long, long time, many, many years. Mm-hmm. And it's true. We don't want women that don't represent us well in a place of high power. We don't. We want good people in there that prove, like, hello, we rock this stuff, and we do. So I'm just saying, as a woman, it's an interesting time. And I also believe we're also in a time where we need to look at what's happening, if you are changing, if you're going through a transgender change, if you are gay, if you're black, if you're pink, purple, orange, whatever color you are, we have to kind of really get to this point of when you're looking at a work situation, look at what you can do, and the reality is a lot of people have been cut away from being able to do stuff, being able to get the training. And so these laws sometimes sound stupid, and sometimes they are like, but at the same time, it's a step. And so I'm just saying, I just didn't mean to get political, but people should just have the opportunity, and if they shine,
they should
yay.
Be able to,
if they don't, why aren't they shining? Is it just that they don't understand? Is there a better way? That we can do things better. And I think that, the law does provide stepping stones towards that. And isn't that part of why you're an attorney, Ward, is that you can make changes. You can fix things. You're the fixer, man.
Yeah, well, I don't fix policy. That's not where I belong. But I fix individual situations. Yes, I really try to help people in individual situations based on the policy.
Yeah,
absolutely.
And it's interesting because you do the business and then you do the employee, and that's something that, I know when we talk business, I'm like, employees, listen to Ward's interviews, read his articles, because it's not just about the employer, it's about you taking ownership of your life, your career, how you're going to move forward in your world. What are your goals? Take a listen to this, because you're going to end up in situations throughout your life in any career, and you're going to have to take a strong look. When do you fight? When do you not? When do you keep quiet? You've got to know the laws before you know how to answer those questions. So anyway, Ward,
yes.
Let's talk about the waiver.
I'm still here.
I know. I'm not. I'm trying to be good, but
are you running
waiver
for office, Lisa?
No, I'm just like, I'm kind of passionate about what happens in the workforce, and then I go like, God. Sometimes I'm like, thank God we don't employ people. It's so hard, But waiver of right to testify. This is something very important too. This is interesting.
Yeah. There really are two situations where this happens, but there's the situation where a person is given a bonus or a raise or something, and they can sign an agreement that says, I won't press a certain type of case, or I won't I won't be a witness against the employer. So I've even seen things that broad, which are really broad. Generally, a lot of these laws, I think, for the most part, lawyers have been following anyway, because there are other laws that kind of touch on it, and you don't see too many like settlement agreements where they say you can't talk about the facts of the case. I mean, you see them sometimes, but usually you can't talk about the facts of this agreement. But there are certainly situations where you may be called to testify by a court or legislative body, and as long as it's done by subpoena or a court order, then you can. Then no contract that you have with an employer could prevent you from testifying. And that has always, honestly, that's always been the law, and so I'm not clear on why they redid this one. I think they thought that there may have been some abuses in the employment area, so they wanted to touch on it directly. But most of the settlement agreements I've seen, at least settlement agreements, now this is broader, so it could be just, like I said, contracts for bonuses where they're asking you not to do this type of thing. So I guess they've broadened it. That's probably really where this the idea behind this lies, and they've also reinforced what's commonly been going on in settlement agreements anyway. If you're subpoenaed, the settlement agreement can't prevent you from testifying.
But can they fire you?
And that's what this is really
afterward? About. Can they fire you afterwards?
No, absolutely not.
Awesome.
In a settlement agreement, normally you've left the company, and that's not always true, but normally, and so you wouldn't get fired anyway. But even if you didn't leave the company, you certainly have protection. Now, if you violated the settlement agreement, I suppose that they could try to terminate you. But what they're saying here is, no, you've got protection. You're allowed to do the testifying. They cannot terminate you because you testified.
Cool.
Now, you've also got a discrimination claim waiver, and that's interesting. So this is about employers may not require employees to waive their rights to sue for harassment. This is interesting.
Yeah. Now, this is really specifically in the bonus or raise context, where an employer may say, hey, I'm going to give you the bonus, but before you get it, you just got to promise not to sue us for harassment or discrimination.
That's bad.
Yeah, and the idea behind it is, now it's kind of weird, because if it's past harassment, I think you can, because if you give more consideration, which generally means more money, to the person, then you can waive your right to past harassment. But if it hasn't happened yet, that's a whole different thing, and the law generally doesn't allow you to say, well, if this were to happen in the future, then you can't sue us, even though it hasn't happened yet. That the law just doesn't allow that.
The fact that you even bring it up or say it makes you feel like it's about to happen.
So I think what they're really focusing on is the situation where, well, maybe someone has talked about an employee has said, I think I might have been harassed, and they've told HR. Now it's bonus time. And they say, hey, we want to pay you this bonus. Good job. And we'll probably pay you a little extra, because you got to usually give a little extra consideration, more money, to get the waiver. So they're waiving the harassment claim. And if you sign this, you got to promise that you won't sue us over harassment. So in that situation, that could be a binding agreement, and it could waive it. Now, I'm assuming this already happened. So what they're saying is you can't do that.
It sounds like blackmail.
This is crazy.
It sounds like blackmail.
Employers do have a lot of power, and they can abuse it. There's no doubt about it. I mean, they cut the check. So,
and you make a choice.
Again, I think most employers are fantastic. I really do. But, there's some who, abuse the law a little bit, or abuse their power a little bit. And so, this would be one situation where the legislature said, hey, they can't waive this right to sue. Sorry. Now, there certainly are settlement agreements that you're allowed to waive your right to sue in, but you can't do it in the context of a bonus or a raise.
Okay. So now what about the settlement confidentiality clause? I mean, this is like, dude, this is like, I mean, this is dude, next year is going to be crazy. So, like,
This is a more difficult legal year for employment changes. There's no doubt about it. It's more subtle. It's more what I would call a lawyer's change in laws. A lot of people aren't going to really understand it, but it can have big effect. So when now it's possible for you to say have a confidentiality agreement that will waive disclosure of the facts of the claim. It's possible. And again, there's so many other laws that sort of touch on that, and that generally you don't see this kind of thing. What you really see is, well, you can't talk about the settlement agreement itself, but not about the facts that raised it, except maybe you might limit it. It's possible. Anyway, so this is just taking the bull by the horn and saying, well, there's no gray area now. If you have a claim for sexual harassment, discrimination, or assault, then can't be a settlement agreement with a confidentiality provision that prevents the disclosure of those facts, of the base facts.
Wow. This is going to be interesting. 2019, Ward. Oh, my gosh. Okay, so real quick, let's get to the money.
Let me bring up one more thing. This is kind of like the Donald Trump thing.
I know. This whole conversation.
Okay, so I think that maybe brings it home better. Stormy Daniels isn't allowed to talk about the situation.
Exactly. This is a big thing.
And this would say that Stormy Daniels is allowed to talk about the situation and doesn't have to worry about being sued. So I think that brings it home.
But it was even before Stormy Daniels, it came with the Me Too movement, was about some of these agreements that people were signing. And it even started in the media thing. So it's the same thing, Weinstein, Trump, all of that, whatever was going on, that you should be able to speak. And it's a very, I think this is going to be so interesting, especially in California. You do have all the Hollywood stuff, You have politicians like everyone else do, but you have all the Hollywood stuff.
If you're,
it's going to be crazy.
If you're called into a court of law and, you put your hand on the Bible and they say, swear to tell the truth, nothing but the truth, so help you, and then you lied because you signed an agreement, it's kind of like you should be able to say exactly what you want to say.
Yeah. And I would like to do something on the statute of limitations of how long you have. I mean, that's bogus too. Like you should be able to speak 20 years later if that's the only time you can. So just saying.
Well,
get on to that,
I mean,
Stop making policies.
Yeah, wow. I mean, the reason why they have statute of limitations in general is they say, hey, if the case gets too old, evidence fades, memories fade, documents get destroyed, la-di-da-di-da. It's just try it. The policy is try it more quickly, bring it into court more quickly, because we don't want to hear a case where the evidence is tattered. Yeah. And it just, so that's the danger they're trying to avoid by statute of limitations. That's in all types of cases. Every case has a statute of limitations.
Yeah, I get that.
Well, except for murder. Murder has no statute of limitations.
Oh, yeah. See, but rape, you have a limit.
Sure you do.
If you were raped as a kid and then you only figure it out later, like what was going on, and that's, too late. Sorry,
well, actually they do have those. I used to practice criminal law, but they do allow a child, especially if there's like memory lapse or whatever, to the statute of limitations will not run until they're 18. For these, and I'm a little hesitant because I haven't looked at that statute in so many years. I can't tell you all the details, but there are some protections for that.
It's like everybody goes through something different, unique, right? And I think, it's just, We're going to have a busy year, Ward. 2019. My gosh. Okay, you got to give everybody the heads up on minimum wage, salary history, minimum wage. It's happening again. It's raising up.
Yep. Well, this law was passed a few years ago, and it's going into effect incrementally. So now on January 1, employers who employ 25 or fewer employees will now have to pay at least $11 an hour in the state of California, and for those who employ 26 or more, it'll be $12 an hour. Now, there are many cities that have different laws. San Diego has one, and the minimum wage for the city of San Diego, and that's not the county, not Julian, some of our other favorite places.
San Diego in the mountains.
But it's the city of San Diego, has $12 per hour. So that would be $12 per hour for all employees. Employers, excuse me. Both employers and employees. And then there are other cities, like San Jose, for instance. I think they're going to jump theirs up to $15 an hour this year.
Yeah,
San Francisco's like $14, and LA has a mixed one. Some are 15, some are, like 13 or something. And if I get a case in one of those areas, I'll have to look that up to see the specifics. But
San Jose,
a lot of cities have different ones.
I want to do a segment with you on San Jose. I've been reading a book about people moving into San Jose, and it's fascinating about how it's changed, about minimum wage, about people and minimum wage, and how it has changed through the years. So anyway, that's another segment on that, because it's interesting that you brought up San Jose, because I'm reading a whole book on it, and we may have to report on that from our Love Your Parks tour mission, possible law and order and minimum wage in San Jose. But salary history, so this is interesting too. We've got to touch on that because... Yeah.
Well, we talked about it last year when it became a new law, and the gist was that employers aren't allowed to ask applicants for jobs about their salary or wage history. And the idea behind that was partly the sexual, the law that protected wages for people of different genders and different races and things like that. So the idea is you can't inquire into that stuff because, part of the idea was anyway, because women haven't been making as much in the past as men, and so you don't want them to base the new salary in the new company on the old salary that wasn't up to par. So that's part of what's going on here. Now, they've decided, though, that there are certain problems with the law the way they wrote it. So now employers can ask an applicant what they expect to make, whether it's hourly or salary. And if an employee says, "Hey, I need to know what the potential wages for this type of employment is," then the employer doesn't have to give them a specific number; they can give them a wage range. And the only employees who can ask for that are new applicants, not in-house applicants. They don't get the wage range; they're not entitled to it. They can get it, but they're not entitled to it by the law.
Wow, that's weird.
There you go, everybody. Ward's article is up on BlendRadioandTV.com. We'll also publish it in the upcoming January through March issue of Parks and Travel magazine for everyone in the hospitality industry, and you'll see it in Big Blend Radio and TV magazine coming up in February. But again, you can go right to BlendRadioandTV.com, and everything we're talking about is there now. Ward, we're going to play a song for you.
Oh, good.
You were a finalist in the Craven Raven Cocktail Contest, and it's happy hour.
That why? Okay.
So we're going to play Road to Reason from the Craven Band. You helped to make them get their cocktail for their band. Okay, so you came third, but you got swag. You got.
Wait. No, I came in fifth. What are you saying?
Fifth. I meant third.
You said third.
No,
I remember these things.
Ward. There's no difference to me. Once you're third, you're fifth. It's all the same. And once it's a fifth, it's a third. There's no difference. You're such an attorney on the details. Like, come on. No, but you had the Craven Raisin martini, and I thought that was cool. You were smart about it. I'm like,
it was a great name. We can all agree on that.
Yeah. But the winner had rum, and that wins. Okay, so that's that. Lisa,
yeah, that drink was killer. That was a killer drink.
That was a good
really
cocktail.
Good drink.
But so was yours. I enjoyed all of them, but that happens. But so we're going to play Road to Reason because that sounds like it should go with with law from the Cravens, and everyone can keep up with the Cravens at cravenssongs.com. And then the thing is, go to Ward's website. Everyone, employers, employees in San Diego and California, go to bestemploymentattorneysandiego.com. He's also on Twitter at Ward Heinrichs, and type in Ward Heinrichs, and you'll find him on Facebook as well. Happy holidays to you, and thank you for our mission, Ward. We accept we're going to have a good year, 2019.
Absolutely. I'm looking forward to 2019, and thanks for having me on, and you guys have a great holiday, too.
You too, and behave yourself.
Yeah, right.
Here's some road trip music for you. All right, here it is, Road to Reason. Everyone stay tuned. We've got an awesome musician coming on, Elliot Lewis, next. So here it is, Road to Reason from the Cravens. Bye, Ward.